My name is Susan Resley, and I'm a partner at Morgan, Lewis & Bockius in San Francisco. My one big thing is disclosure. With its arsenal of data analytics tools, the SEC will be assessing the adequacy of disclosures surrounding the coronavirus. For example, a company that merely discloses that it may close certain locations as a result of COVID-19 may find itself scrutinized or worse yet investigated if in fact it closes those locations in short proximity to the disclosures. The SEC doesn't expect companies to have a crystal ball, but as always, it will expect companies to accurately disclose what has happened, what it knows will happen, and what it reasonably expects will happen as a result of the coronavirus pandemic.
Okay, welcome everybody. Our first panel today deals with, I think we can all say, the most pressing issue of our time. Not an exaggeration to say that COVID-19 has impacted everything on a global basis. And this very much includes the world of securities enforcement and litigation. And this panel is going to break down how that is affecting companies and the lawyers and the other professionals who are advising them. So let me start with our moderator, Kaz Hashemi. Kaz is the chair of the litigation department at Wilson Sonsini, and he has represented companies and boards in more than 100 SEC government and internal investigation matters during his career. Kaz is also a veteran of the SEC Enforcement Division. Now at Wilson Sonsini, where he's been for almost 15 years, he's built a global and multifaceted SEC enforcement practice. Kaz, I look forward to hearing your thoughts, and welcome.
Hi, Bruce. Thanks.
Let me now introduce Thomas Heck, a KPMG partner who specializes in forensic accounting. Tom has over 14 years of experience in assisting clients with a wide range of forensic services, including commercial insurance claim assistance, litigation support, financial reporting, and securities investigations, and particularly in the area of business interruption, which is a great fit for this panel on COVID-19, which may be the ultimate business interruption. So glad Tom is here to help kick things off. Welcome, Tom.
Hey, Bruce. Thanks for having me.
Next up is the SEC staff member of this panel, Jason Lee, who is Assistant Regional Director and a member of the Public Finance Abuse Unit in the SEC's San Francisco Regional Office. After 6 years at a big law firm, Jason has quickly risen through the ranks to senior management at the SEC. We're very interested to hear from Jason on this panel and really grateful that he's here. Welcome, Jason.
Hi, thanks for having me. I'm happy to participate.
Finally, Susan Resley, who leads the SEC enforcement practice at Morgan Lewis and who also cut her teeth as an SEC enforcement staffer out of law school. Today, Susan's clients range from boards of directors and audit committees during investigations to public companies and C-suite executives during litigation and class actions. Certainly no surprise that Susan was recently named one of the top women lawyers in California by the Daily Journal either. Can't wait to hear your take on the topic, and welcome, Susan.
Thank you, Bruce.
All right, Kaz, I'm turning it over to you. Thank you.
Bruce, thank you so much for setting this up, and thank you all for joining us today. When this pandemic started, I don't think any of us knew how this was going to affect our daily lives, society, or work. And now a few months into it, we're adapting as best as we can. And this includes in our new professional environment. For the securities enforcement and securities litigation bar, things are happening. The SEC has imposed trading suspensions on companies concerning statements about COVID-19 vaccines, test kits, and treatments. So should we expect more COVID-19 related cases from the SEC? The SEC has also encouraged broader and more detailed forward-looking statements. But what kind of risks do those more detailed statements cause for companies? In securities litigation, there's been a couple of cases filed regarding safety and development of vaccines. But what lies ahead in private securities litigation in light of the stock market volatility and some unique issues presented by COVID-19, and what kind of discovery awaits us? For the accounting practice and auditors, what impact has COVID-19 had on audit procedures and practices? Well, we have the perfect panel to deal with these questions: a senior member of the enforcement staff, a partner in a major law firm, a partner at a Big Four accounting firm. So let's start with first Jason, tell us a little bit about how investigations are being conducted at the SEC. I think all of us are interested in some of the nuts and bolts of how the staff is conducting investigations in this new world. I know you have to give a disclaimer, but we'd love to hear some of your thoughts on that.
Sure. So I'm glad to have the opportunity to participate on this very timely and relevant panel. Just as an initial matter, I wanted to make note that the views I expressed today are my own and not necessarily those of the commission, individual commissioners, or my colleagues. So with that aside, what is business as usual, if we can call it that during this situation? What I'd say is that although most of the enforcement staff at the commission is working remotely, virtually all of us, business in a lot of ways is operating as usual. People are still working actively on their investigations, conducting witness interviews and testimony, and I'm happy to talk a little bit more about that in a bit. Subpoenaing records, reviewing documents, and conducting regular meetings. Staff is continuing to monitor the market and securities industry for possible violations, and where appropriate, opening new investigations. And enforcement staff is also continuing to initiate new litigated and filed actions, just like prior to the COVID-19 pandemic. What's different, of course, is the logistics changed with meetings and testimony, mostly and often being conducted by video via WebEx, and sometimes by phone as well. From what I've observed and understand from talking to others, is that the video testimony and interviews and our operations remotely have by and large been effective and productive. Obviously there's going to be, an occasional technology challenge, but I feel like with folks here at the SEC and the people that we've been interacting with in the public, if there's clear communication and planning and discussion of process leading up to, for example, a WebEx testimony or something of that nature, the process typically has gone pretty smoothly, replicating more or less a lot of the interactions we'd have if we were in person, although obviously accommodating for health reasons and other reasons, the shelter in place and stay-at-home orders. I just say broadly that we remain vigilant and active in our investigations, so we're still going. As you mentioned, the trading suspensions. And the last thing I just flag is that we are trying to keep in mind, are obviously aware that circumstances have changed for everyone, right? This has affected everybody in many ways. And so one way obviously is, the logistics of someone responding to a document request or in any other way responding to an inquiry from commission staff. We're very cognizant of people's lives have changed, entities' logistics have changed, our lives have changed, right? So we've certainly been very cognizant of trying to be reasonable and working with people to get the best result, and having a clear dialogue, as I said, about how do we get materials and things to the SEC so that we can expediently carry out our responsibilities, but at the same time recognize and be realistic that circumstances have changed for others.
So Jason, interesting about testimony and exhibits. I know the staff in normal circumstances is pretty cautious about its exhibits and sharing, obviously, before testimony. Is there any flexibility now in this new remote environment and sharing documents or exhibits that you plan to use during testimony prior to the testimony? Is it on a case-by-case basis making that determination?
I would say it's a case-by-case basis. I think pretty much most interactions with the SEC now are going to be, it always was case-by-case, but it certainly will be even more so now depending on circumstances. I think where appropriate and depending on the staff involved, so every individual or entity and their counsel, should, if they have counsel, should engage in that dialogue with the staff member they're engaging with or interacting with. But yeah, there are instances where it might make sense to send some, if not all, exhibits to a witness prior to or maybe the day before, the morning of the testimony. I could see that happening where a document's an already a public document, for example, or if something is a very large document that might be cumbersome to show via WebEx and just flip through that way. There will be times, though, where all or some documents will remain where we won't share them prior. And what we've been doing there is through WebEx, showing it that way. And it's worked to, by and large, a great degree of success. I mean, to be realistic, for larger documents, it will slow things down potentially. But that's what I was talking about in terms of process and everyone talking about it beforehand and having the right expectations and being patient. It's worked out pretty well.
Okay, great. And for the Zoom folks that are running this, you'd run Zoom too. You mentioned WebEx. So Susan, tell me, from a defense perspective, some strategies and thoughts and perhaps challenges in doing remote testimony from your perspective.
I mean, I will echo what Jason said first, that the staff has been fairly flexible. What I try to do in the first instance is offer an attorney proffer, just to ease things, to give a sense to the staff that we're cooperative, but that there are challenges, and it may be more efficient in the first instance to do an attorney proffer. If that's not going to work, then you're in the remote world, and it is much more time consuming, certainly very time consuming in prepping your witness and your client, getting ready for the testimony. And then, as Jason said, just the logistics for those documents that you aren't shown in advance, the amount of time it takes to scroll through and then perhaps go off the record and have a separate conversation, with your client. And I tend to do that offline. I'm not confident enough in my own abilities to enter into a prior chat room on Zoom. So, my tip, just for my own purposes, is you're probably better off to just sign off, turn the video off, and go on mute and have a separate conversation with your client on breaks.
Yeah, what do you think of perhaps a testimony of a person who actually faces potential jeopardy of an enforcement action and a desire, and you miss the opportunity to have them meet face to face with an enforcement staff attorney who may be making that decision? That also creates an additional challenge about how to approach such a circumstance and whether to ask for a delay or some form of waiting to see if we can actually do it in person.
I think that's exactly the point. I think if your client is seriously in harm's way and, having an opportunity to actually sit across the table as opposed to across the screen really helps in the staff assessing credibility and you assessing how the staff views credibility as counsel. And that goes to the, proffering in advance and trying to work through a delay. And if it ultimately means that you have to enter into some sort of a tolling agreement, which I'm not a big fan of, you have to really look at what's in your client's best interest. And right now, we just don't know how long this is going to last and how long we're going to be in a remote world. But I think for a client or someone who is seriously in harm's way, you really need to assess the possibility that it's really in your client's advantage to have live testimony.
Right, and you mentioned tolling agreements. Jason, are you seeing more efforts to send out tolling agreements to companies and especially individuals in light of the current situation and associated delays?
Yeah, I think it makes sense that tolling agreements is an option and possibility on the table. And again, this is part of that dialogue among the staff and folks in the securities bar or any counsel involved about figuring out what's a reasonable approach that balances timing, but also the factors that Susan just mentioned. I feel that this is a constantly fluid and changing situation, right? The progression of the virus itself, shelter-in-place order variations as different states and counties and cities try to open up. So things are in flux. A tolling agreement might give some flexibility to wait and see for a month or so, something of that nature, right? But I think we can all agree, or for thinking through logically, that an indefinite delay may not be in the best interest, and certainly from the SEC's perspective, isn't something we really can entertain. So again, it's talking through, figuring out the best options, and the staff is trying to be flexible and thinking about what are reasonable steps, first step, and if that doesn't work, then what's the next best step.
Okay, great. Staying with you, Jason, you mentioned, and I did too, about the trading suspensions that the Commission imposed since March. Can you give a little bit more detail on that from the staff's perspective?
Sure. Unfortunately, there are those who would try to capitalize on crises like this current pandemic for their personal gain, including at times through market manipulation and deceit in investors. So just broadly speaking, the Division of Enforcement is committed to swiftly stopping any COVID-19 investment scams, including through trading suspensions where appropriate. So I think that as of last week, the Commission had suspended the trading of around 29 securities with some nexus to COVID-19. And the nexus is varied. I'll just give you kind of a high level. You actually touched on it a little bit earlier, but there have been suspensions where information in the market about either the production or supply of PPE, right? We've been hearing all about that in the news, personal protective equipment. So N95 masks maybe was inaccurate, or there were concerns about the accuracy of that information. There was the Praxin Corporation, for example, was one of those trading suspensions, Sandy Steel Unlimited as well. Other suspensions have related to statements or information about the availability of COVID-19 test kits. There have also been suspensions related to statements about developing a vaccine within 3 to 6 months, potentially, for COVID-19. The sort of variations continue. The last I'll just mention now is statements that there were concerns at the Commission in terms of the veracity of those statements about a treatment for COVID-19. So about using cedar leaf oil as a treatment, for example. So basically our concern about those statements, potential manipulation, pumping up of often what we call penny stocks, right? Microcap type securities. And those have led to those roughly 29 or so trading suspensions.
Right, and then there was also a 10B case brought for a false statement. I think that's the only one that I'm aware of. Can you give a little background to the audience about that?
Sure. So you're referring to the Praxin Corporation civil complaint that was filed on April 28th in the Southern District of Florida. So Praxin was subject to one of those trading suspensions that I mentioned. And pretty soon thereafterwards, the Commission filed that civil complaint against both the corporation and its CEO, Frank Brady. Generally speaking, the allegations are that the company and Brady made false and misleading statements related to the procurement and ability to supply and interest in their supply of N95 and similar protective masks that would supposedly help minimize the risk of someone getting the coronavirus or COVID-19. The allegations in the complaint were that those statements were false and unsupported in terms of actually having any masks on hand, actually being able to contract with suppliers to get those masks, and actually having had inquiries from customers to get those masks. And so the charges were under Section 10B of the Securities Exchange Act of 1934 and Rules 10b-5A through C. And that's against both the corporation as well as the CEO, who is quoted in the 2 press releases at issue. And I would just note that, again, I think this is just an example of how our business has continued as usual in terms of non-COVID cases, certainly, but there is a focus as well on stopping quickly and holding to account those individuals and corporations involved.
Thanks, Jason. Susan, as I mentioned earlier, the SEC issued some language encouraging companies to give broader and more detailed forward-looking statements. Can you cover that in a little bit more detail and talk about some of the implications? Easy to say, maybe some companies have some challenges in thinking about how to implement.
So on March 25th, the Division of Corporate Finance issued guidance under a very, very catchy name, which was Disclosure Guidance Number 9. And what's in Disclosure Guidance Number 9 is some guidelines as to how to disclose for risks associated with COVID-19. And in a nutshell, the SEC is going to be looking at hypothetical and boilerplate type disclosures. They want a company to assess how COVID-19 has affected their business. So, for example, shelter-in-place orders and remote working arrangements may well have had a significant effect on sales and salespeople's ability to go out and bring in business. I think it's fair to say that the SEC doesn't expect clairvoyance, but they just do expect that a business at least describe what has happened and what reasonably will flow from the effects of COVID-19 on their business. So the kinds of disclosures that may have been appropriate previously, things like COVID-19 may adversely affect our operations, but we can't predict how, is something that will be scrutinized, as opposed to saying something along the lines of COVID-19 has adversely affected our operations and our ability to continue to do business. And we expect, as opposed to we may, that it will have an adverse effect on our financial operations, and though we can't predict how. So you're still giving yourself some wiggle room, but you're also at least apprising what is currently happening and at least what you think will happen down the road.
Right. And then, Susan, as companies get into perhaps following that more detailed forward-looking statements and broader disclosures, there is a potential inherent tension between giving that and exposing yourself as a company to private litigation if something turns out differently. So from a defense perspective, how do you advise companies to deal with that tension?
That's a very, very real tension. Following the guidance, the Chairman Clayton, as well as the director of CorpFin, Bill Hinman, said that robust disclosure benefits all investors. But I think realistically, we all know that no good deed goes unpunished. So you really have to balance it, because any disclosure is going to be looked at with the benefit of hindsight. So you're certainly safer by describing what you know, or what you know is coming right around the corner, and describing how you think that will affect your business going forward. It's a really, really delicate dance, but I think certainly there have been some examples of both the SEC and private plaintiffs seizing on vague risk disclosures, talking about what may happen when in fact the company knew that this was happening or it was going to happen. So, it's a very difficult balance, but it is something that, certainly the SEC and private plaintiffs are going to be looking at.
Jason, on these more detailed forward-looking statements, and I know we talked about it a little bit in our session as we're preparing for this, should companies be concerned about the SEC coming and second-guessing those more detailed disclosures if things turn out differently?
Right. So a couple things. What I do is, first of all, the statement by Chairman Clayton and Director Hinman is available on the SEC's website. So for anyone interested in taking a look at it, I think it's a pretty good read and explains the rationale behind the statement. It's on the website, as are all the trading suspension orders I mentioned earlier. What I just say is that the statement itself mentions and encourages that companies should avail themselves of the safe harbors for forward-looking statements when providing this additional guidance that's being discussed and encouraged. And the statement also notes that there's an awareness that actual financial and operational results may differ from what would appear to be a reasonable estimate at the time guidance is provided. And the statement also references that, given the uncertainty in the current business environment, there's an expectation not to second guess good faith attempts to provide investors with appropriately framed forward-looking information. So I just stress, good faith attempts and reasonable estimates, right? I think everyone's trying to adjust this situation and get accurate information to the market that can impact and, benefit both investors, companies, but also the economy as people try to rely on accurate information being provided by various entities and issuers that they need to rely on to get back online and operate effectively and get markets going, economy going. So good faith reasonable attempts, reasonable estimates?
I mean, I think the good faith test is it, because literally from day to day, we really don't know. And I think that's helpful to know that. And I think that the staff will be mindful that you're operating under good faith and that everybody's really in this, from day to day.
Right. Especially trying to give detailed forward-looking statements about something, as you just said, is changing almost on a daily basis. Well, Tom, let's get you in here. You're a partner at a Big Four accounting firm, KPMG. From what is the COVID-19 impact on the accounting world and auditors, procedures? Give the floor for you for a little while to give our audience some perspective on that.
Sure, Kaz, and thanks. I know it's early here on the West Coast, so don't mean to put people to sleep with some accounting talk, but just first to cover some accounting-related incentives and opportunities and things that we could see in the market right now. I think the COVID-19 business environment or the recession that we're in or coming upon is a little bit different than recessions of the past. I mean, I think particularly we have a bit of a bifurcated situation here in the market. I think you have a number of industries that are extremely distressed and troubled. And then we have a number of industries that are booming. So, the complete opposite. So, and there's different kind of incentives and opportunities to be on the lookout for financial statement manipulation as it relates to both of those. Just some things to cover as it relates to distressed industries. Companies and folks should be on the lookout for, that hero mentality. Certain incentives of senior level executives to save a business unit, a division, or a company by performing creative accounting measures or, pushing things to the balance sheet instead of recording them in the income statement and things of the like. Some of the areas of estimate and judgment that can be manipulated to easily accomplish that is revenue recognition, manipulating reserves or contingencies, fair value and goodwill impairment considerations. Companies can mess around and take aggressive tax positions and FIN 48 related matters. And I think two very important things that are very timely right now is I think a lot of distressed companies are getting immense pressure to either meet debt covenants or if they break those debt covenants, how is that going to impact them? There are a number of estimates that go into a lot of the debt covenant calculations. So there's some incentives there to manipulate those estimates. And then also, which I'll jump into a little bit when I cover some technical accounting things, but just the application of any government relief that certain companies are receiving and how to account for those. There's a number of different kind of applications that can be taken by companies across many different industries here. And I think that goes into the importance of, the disclosures that Jason and Susan were talking about and how companies are treating that. Alternatively, in the booming industries, I think if a company, if they're, we think of the Costco's, certain retail shops or grocery stores and the like are probably seeing some record quarters and some record earnings. They have a risk of padding reserves or building up cookie jar reserves, an incentive to maybe pull forward expenses and recognize things now while things are going so well. They also have a concern of just their supply chain and being able to serve their customers. I mean, if we look at the toilet paper shortages in the United States, that's a big disruption where folks can, struggle with their supply chain recent times here. There's also an effect on the workforce right now, and I think that can significantly affect internal control. Particularly many companies facing, rifts or reductions in workforces or furloughs, they may be faced with issues of, can they still accomplish the same segregation of duties that they like with the same amount of oversight around, all of their financial statements and the related work that goes into them. There's also a potential increased rationalization for employees, I think, to commit fraud, especially with these remote and kind of different working environments and conditions. I think for certain employees that they thrive or enjoy working at home. Others like to be in that team environment, working not remotely, but in an office. So that kind of just gives a different spin to rationalization, and depends how folks are wired, but there could be some risk there. There's also, and I think I've seen this particularly at KPMG with our clients, but I'm sure it is market wide, there's just an immense increased risk around cyber attacks, social engineering, people logging in and manipulating other folks' books and records or financial statements. I think we're all seeing, and I know we talked about it when we were prepping for this panel here, but this new remote work environment and what that means, and people being able to log in or manipulate others' financial statements.
No, please go ahead.
Go ahead, Cass.
No, please finish.
I was just going to jump into some audit related considerations. So if you had something there, I can.
No, that's perfect. I was going to ask about how has anything changed in terms of how KPMG or the Big Four, are approaching audit procedures and accounting disclosures and SEC filing, because a big part of auditing a company is being on premise, talking to folks, looking at the books and records on site. We're all used to having the auditors have a big conference room or something at a company. So how's that working out post COVID-19?
Yeah, absolutely. And I think, that face-to-face time with clients is so important for our audit teams. And I was chatting with some of our audit partners as I was prepping for this panel, and they said that the ability to ask a question and read a client's reaction, it's imperative. It's so important in performing our audits and maintaining that high level of professional skepticism. So I think not getting face-to-face time with the clients currently, one of the things we're trying to do is conduct walkthroughs and interviews via Microsoft Teams or Zoom, like we're doing here. And I think that's important. And also, just modifying risk assessments, as we were planning for our audits, both the year ends and the quarters, we do a preliminary risk assessment. I think circling back through, taking another look at that risk assessment, modifying it for the current work environment today, and also, stressing the importance of unpredictability when you're doing selection and testing, and the timing of doing things, I think, is very important when you lose that face-to-face time. So obviously you're not going to be able to get as much face-to-face time, but accomplishing that through Zoom and Microsoft Teams or whatever, Skype, whatever else you may be using. And then also adding that, the unpredictability and doing some different testing and some different samples. I think a simple example of this is really just I was chatting with an audit client. We were helping them with their their CARES Act. It's a healthcare related entity, and the audit partner just said, listen, at the quarters we normally do some simple substantive testing of vertical and horizontal analyses, see how financial statement accounts moved and trial balance accounts moved, and right now with COVID-19, that is completely useless. You can run as much horizontal and vertical analysis as you're going to want. You're going to have numbers and percentages that are all over the map that normally would not be that way. So it's just a normal procedure that they rely on that is now rendered to be almost useless. And other substantive procedures and alternative procedures have to be kind of identified and worked on in that regard now. Just to jump in and give some quick technical accounting examples, I thought would be relevant here, and some ways that our companies and our clients are being impacted by COVID-19, particularly as it relates to financial institutions or banking clients. The CARES Act did a number of different things, but for financial institutions, two very important things that they have an option to do now is under Section 4014 of the CARES Act. It actually allows financial institutions to delay the implementation of CECL if they haven't yet, which is the allowance for credit losses and financial instrument losses. That's a big piece of accounting. It's a big undertaking that many financial institutions have been going through. The CARES Act allowed certain entities to delay that to the earlier of this coming year end, so December 31st, 2020, or until the national emergency is terminated. So, there's an example of a pretty big decision that a bank can currently make that they were supposed to be, implementing a very big change there, accounting for credit losses, and they can delay the implementation of that. Similarly, Section 401(3) of the CARES Act allowed financial institutions to not elect the GAAP requirements to loan modifications for troubled debt restructuring. Again, kind of related to the CECL accounting stuff. So, those are two examples in the financial institutions and how the CARES Act and COVID-19 have given them kind of an opportunity to change their accounting practices. Similarly, in a different industry, in healthcare, we see a lot of our clients receiving funding under from the CARES Act and the Provider Relief Fund. Particularly $50 billion has been pushed out to date thus far. And how do these healthcare companies and the various industries that are receiving this funding, how do they account for it? Is this normal revenue under ASC 606, which is, just as you would treat a patient would come in? Is it grant revenue or government accounting, how this money comes in? Or is it a gain contingency under ASC 405? I think there can be different arguments made for all three of those. And we see a lot of healthcare and hospital clients, struggling with that and trying to get that figured out. I think to what Susan and Jason were talking about earlier in disclosure, for Q1 filings, that there have been a number of healthcare clients that have already filed financial statements that we're seeing. That's just that they're treating any funds received under the Provider Relief Fund there as a Type 2 non-recognized subsequent event with just disclosure in the Q1 filings. But come Q2, that's going to be the time that they're going to have to see, adopt an accounting method and have those disclosed and accounted for in their, their June 30th filings. So generally, I think what we're seeing is these are going to mostly be falling under ASC 958, so that would be the government and grant accounting. But it is something where the healthcare industry needs to really take a hard look at this stuff and determine the best way to account for these in their filings.
Got it. Thank you very much, Tom. Susan, switching gears a little bit, going to the private securities litigation world. I know there's been a few cases filed. Can you give your perspective on those?
Sure. I'll spend a couple of minutes. There are two that have really been most top of mind, and they deal really with the industries who are most in the news right now, which are travel and leisure, as well as in the healthcare vaccine. And so the first involves Norwegian Cruise Lines, and the class periods in both of these cases are very, very short. So in this case, in Norwegian, the class period began on February 22nd, at which time Norwegian issued an 8K that really spoke highly of the proactive measures it was taking in connection with safety of passengers that were on its cruises, and that it was well equipped to handle, pandemics, including COVID-19. The class period ends less than a month later on March 11th, when the Miami Herald published a number of leaked emails and scripts that came from Norwegian sales department, where there were some real high pressure sales tactics, encouraging salespeople to really get out there and try to bring in as many passengers. And some of the scripts said things along the lines of that the virus will go away when warm weather comes. Medical experts say there will be no COVID-19 summertime. The only thing you really need to be worried about is having enough sunscreen. And apparently there was, some very significant pressure. And according to some of the documents that were leaked, there were allegedly threats that some people would lose their jobs. So needless to say, the stock price plummeted following that publication. It's still very early. There hasn't even been lead plaintiff that's been appointed, but several lawsuits have followed with that same fact pattern. So on a different scale is the case involving Inovio, and in that case, what happened was the company came out and promised that it was developing a vaccine and would have a vaccine out in fairly short order. Perhaps even by the summer, they would be able to start human testing. And that was that release was in mid-February. What happened then in early March is that a short seller activist issued a report calling on, Jason and his team at the SEC, not Jason specifically, but the SEC, to investigate what it described as ludicrous and dangerous allegations. And so that case is also still very, very early on. But this is probably a sign of the kinds of cases to come where disclosures are being, evaluated based on what happened subsequently.
Right, and the security litigation current market raises some interesting loss causation issues. Can you just quickly give our audience your perspective on that?
Yes, unlike SEC cases, in private cases, one of the elements that most of you probably know is that a plaintiff needs to demonstrate loss causation. And loss causation doesn't just mean that the stock price dropped on the day that the bad announcement came out. There, with DORA and other precedent, the plaintiff really has to demonstrate that it's the fraud itself and really tease out that the stock price fell because of the fraud and not because of intervening market events. And we saw a lot of this in the financial meltdown cases in which the stock price was just dropping for things that had nothing to do necessarily with what was actually happening with the company. So it's going to be, I think, a higher burden for plaintiffs to demonstrate loss causation. It's not going to stop them from filing the cases, but it certainly is going to be, I think, a little bit more difficult, maybe a lot more difficult for them to really segregate loss being caused by the fraud as opposed to just collateral to everything else that's happened.
And one last topic it looks like we have a few minutes for, maybe Susan and Tom can jump in, is, and we talked about this a little bit as we were preparing for this, is seeing increased whistleblower allegations with, perhaps employment in jeopardy. A whistleblower allegation comes in, and then you have to do an internal investigation, collect documents, perhaps conduct interviews, and still try to get it done in an efficient and timely manner. So can you, both from a legal perspective and perhaps from an auditor perspective, comment on potential whistleblower allegations coming through in this environment?
I mean, I certainly think that they will be on the uptick. And I think, frankly, even just seeing the leak of documents in connection with the Norwegian cruise line case is things to come. And I think as companies are downsizing, and we're expecting that to happen even more as a result of the economic situation following this pandemic, there will be individuals who come forward and may challenge not only the financial statements, but may challenge disclosures concerning safety issues or what was really happening and what the company knew. So I certainly suspect, given the economic downturn and given what is likely to happen with future layoffs, that there will be a number and a pretty big tick in whistleblower complaints, which obviously every company has to investigate regardless of whether the company believes there's any merit to it. They absolutely will need to do that. So we suspect that they will be on the rise.
So just to add to that, I think to the extent that you have these smaller, medical supply companies even that may have, partaken in some price gouging or some price manipulation of PP&E in the healthcare industry, particularly. I think we could see a very big spike in whistleblower, reporting there and the related investigations that follow that. In terms of an evidentiary perspective, I think it is an interesting kind of time. I know our team has been moving forward with investigations, but it's unprecedented of conducting interviews, whether you do those on Zoom. I think email and the data like that is still easy to collect, but the other kind of components of investigations is taking a turn.
Right. Well, thank you all, Susan, Tom, and Jason, for your thoughts. And I'm sure during today, everyone's going to hear a lot about COVID-19, but thanks for getting us started. Bruce?
Thank you, Kaz. That's a great start to the conference. And thank you to the whole panel. Terrific job. And what a crazy topic and important topic. So thank you. The next panel on cryptocurrency issues begins in 5 minutes at 9:20. So we'll see you after a short break. Thank you.
Bye, everyone.
Thanks.